this special edition of the CLES Critical Conversation series. It's special for two reasons. Firstly, today we are co-hosting this conversation with the Environmental Law Association of South Africa, or ELA for short. And I want to thank Prof. Germarie and Mishka for suggesting that we do it this way. And then also for all your hard work in the background to arrange today's event on our behalf. The second reason why today is special is because, well, typically we host guest speakers from the academic world, but today we have not one, but two guest speakers who are legal officers in the public service. So a special welcome to Lize and Liesl, who join us today from the Department of Forestry, Fisheries and the Environment and the Department of Water and Sanitation. I should add, it was their idea to join us as a team today to discuss this ongoing sewage issue together, and which to me at least is testament to their good working relationship. And this, of course, is very encouraging because, generally speaking, interdepartmental collaboration is vital when it comes to environmental and water governance. As you all know, issues of this nature can hardly be addressed in silence. That being said, Lize and Liesl, we are really eager to enter into a conversation with you, and we look forward to your discussion and to hear more about our water issues from a governmental perspective. Our program for the day looks as follows. Let me just share my screen. There we go. Okay, I hope you can see the program. So first up, we will have Prof. Oliver Fuhr. He's our interim chairholder here at CLES, and he will tell us more about the Critical Conversation series. Prof. Oliver is a professor at the Northwest University. He's a C2 rated NRF researcher, and is also a Alexander von Humboldt Research Fellow, currently based at the Freie University in Berlin. So Prof. Oliver is actually joining us all the way from Germany today. And next on the program, we have Prof. Germarie Vincent. She's the Northwest representative of the ELA, and she will tell us more about the ELA. She's an associate professor at the Northwest University and the project leader of the Environmental Change Research Project at the Faculty of Law. Once she's done telling us about the ELA, our CLES doctoral researcher, Nesia Manguleni, who's our Critical Conversation team leader, will introduce the two speakers, and then we'll hand the floor over to them for their presentation. And this will be followed by a Q&A session that will be hosted by Mishka Diedrichs, who is also a doctoral researcher here at CLES. And then we'll give the speakers another chance to provide some closing remarks if they have any, and Nesia will wrap up the conversation. Okay, before we get going, and this is actually the most important part, just a quick note on the house rules. We have to ask that everyone please keep their cameras switched off and their mics muted throughout the session. And you can unmute your mic during the Q&A session, but Mishka will guide the process. So you can take your cues from her when we reach that stage. And to the speakers, do please remember to switch on your cameras and unmute your microphones when it's your turn to speak. And lastly, please note this session today will also be recorded, and we'll upload it onto YouTube afterwards. So everyone, please be on your best behavior. Okay, Prof. Oliver, if you're ready, please take it away.
Thanks very much, Lawrence. Good morning, ladies and gentlemen. Good morning, Liesl. Good morning, Liesl. Thanks very much for making the time to come join us in today's Critical Conversation series. I want to also thank Prof. Germarie and Mishka and Nesia, who have been able to put this together, working very closely with the Environmental Law Association of South Africa. And I think that is common knowledge that CLES is a research entity which is within the Faculty of Law, within the broader research unit on law, justice, and sustainability. And it is based in the Potchefstroom campus of the Northwest University. And it really forms part of the NRF, National Research Foundation, initiative about creating a number of chairs in the country to deal with specific problems. And this was introduced to the university in 2019 when Prof. Anel applied and successfully secured a chair. And she served as our first chair until last year. So she's been away from us for slightly above a year now. And she's really one of the leading authorities we have in the country in the field of local government law, environmental law, and sustainability. So like Lawrence indicated, my name is Oliver Fuo, and I'm serving as the interim chair. We applied to the NRF to have me appointed as the permanent chair, and we are keeping fingers crossed and hoping that things will go well. As an entity which is really focused on research at the Northwest University, we are dedicated to excellence in legal scholarship and to developing skills, research skills of young stars that we have, a lot of masters, PhD, and postdoctoral fellows that specialize on sustainable urban development and the law in South Africa and also within the broader African regional context. We've had students from Zimbabwe, Cameroon, and we are expecting another one to join us from Kenya. And we also have a number of students across who have come from different universities in South Africa. So our intention is to train them so that they're able to conduct research in the intersecting fields of law, governance, and urban sustainability, focusing also on environmental sustainability-related questions. And our intention, one of our intentions, is to publish good quality research, excellent research, through the dissertations that our students do, and through journal articles, book chapters, and books. We are also working on policy papers, and we want to use that as an opportunity to engage with the broader science community that includes policymakers, government officials, and NGOs in order to be able to sharpen the work we do and to also improve our visibility and publicity. We started the Critical Conversation series in 2019 when Prof. Anel was with us. I've been part of it since 2019. And the intention generally is to be able to reach out to a broader scientific community or a broader scientific audience. Basically, we pick a theme or a topic on any of the issues that relate to the work that we do, and then invite experts to come share their thoughts on the theme or the topic. And members of the public are always free to join us. We encourage and invite them to join us. And the first one that we had in 2019 was at the Faculty of Law. And after that, 2020, COVID struck, we experimented with a visual critical conversations, and that was very successful. And after that, we decided to organize it virtually. So we've been doing that virtually since 2020. The discussion is not supposed to be very, very formal, but we devised a program to be able to facilitate our conversation. So we are going to try and stick to that program. But before I make way for the others to come in, I wish to indicate that this is the second critical series discussion that we are having this year. The first one was presented by Dr. John Rantlow from the University of Pretoria, who looked at the food, energy, water nexus, exploring how the role players involved could be leveraged to be able to promote social justice within the context of our cities. Like Lawrence already indicated, the second critical conversation series focuses on the looming water crisis in South Africa and looks at how our failing infrastructure combined with our inability to manage sewage poses a very significant problem to the ability of our municipalities to be able to provide drinking water. So like he indicated, Liesl and Liesl are going to present, and after that we are going to have questions and comments and engage with them. I want to thank again Nesia and Prof. Hemari and Mishka and Lawrence for making this conversation today possible, for all the organizational work they have done, the planning they did, to ensure that we're able to have a good critical conversation series today. I think that is all that I can say for now. I'm looking forward to the engagement during and after the presentation. Thank you.
Thank you very much, Prof. Oliver. Prof. Gerber, if you're ready, please take the floor.
Thank you, Lawrence, and good morning, everyone. It is my pleasure to just very, very briefly introduce or say something about the Environmental Law Association of South Africa, or the ELA in short. So for those of you that's not yet familiar with the association, the ELA is a non-profit organization and really is dedicated to promoting and supporting the development and application of environmental law and governance in our country. And our members come from diverse backgrounds, include legal practitioners, environmental management consultants, government officials, academics, students, and even environmental activists. So the ELA operates through various branches across the country. And together with Mishka Diedrichs, I'm really proud to serve as the representative of the Northwest branch of the ELA. So if you're not a member yet and would like to get involved, please don't hesitate to reach out to either of us. On that note, please feel welcome also on behalf of the ELA.
Thank you very much, Prof. Gerber. Nesia, I think then I can hand over to you to introduce our two speakers for the day, please, and then they can take over from there. Thanks.
All right. Thank you, Lawrence. It is my pleasure to introduce our speakers today, Mrs. Lize Redelinghuis and Ms. Liesl Vincent. Lize Redelinghuis holds an LLM in Environmental Law and Governance, obtained with distinction in 2017, and an LLB from Northwest University. Lize has extensive experience as a health, safety, and environmental legal specialist. In 2018, Lize joined the Department of Forestry, Fisheries, and the Environment as Deputy Director, responsible for legal support to the Environmental Management Inspectorate. Currently, she serves as a Senior Legal Administration Officer within the Directorate Legal Reform at DFFE. In this role, she provides legal support to all branches of the DFFE with a primary focus on the oceans, coasts, and fisheries regimes. She also provides enforcement support and legislative drafting. Our second speaker, Ms. Liesl Vincent, holds an MBA from Business School Netherlands and an LLB from the University of the Western Cape. Liesl has served as the legal advisor in the Department of Rural Development and Land Reform from 2006 to 2016. She is currently at the Department of Water and Sanitation as a Senior Legal Administration Officer within the Chief Directorate of Water Use, Compliance Monitoring and Enforcement. Today, we are very fortunate to hear their insights on the looming water crisis, unveiling realities of South Africa's ongoing sewage challenges. Please join me in welcoming Mrs. Lize Redelinghuis and Ms. Liesl Vincent. Lize, the floor is yours.
Thank you so much. Good morning, everyone. What a privilege to meet all of you, although it is virtually. I'm very excited about the discussion that we're going to have. So please make your notes during the discussion, during the presentation, so that we ensure that we at least try to respond to all of your questions. Where we don't know the answers now, or we need to go back and chat to our colleagues, we will definitely do that. If you don't mind, I'm just going to turn off my camera just to ensure that our connectivity holds, and then I'm going to share my screen. All right, you should be able to see my screen now. Can someone just please confirm?
We can see it. Thank you, Lisa.
Great. Thank you so much. Okay, so thank you very much again for this opportunity. And like it was already indicated, we are talking about, and I give you 3 guesses what the most prevalent environmental crisis is in South Africa today, and that is sewage. So what we are going to look at firstly is I'm going to try to set the scene for you in terms of the current status of our wastewater treatment works in South Africa. And the dire situation that we're sitting in relation to our failing systems currently and our water and ground pollution. Then we're going to look at the mandates and the duties of municipalities in terms of our legislation. Then we're going to dive in the typical offences that are associated with the unlawful disposal and discharge of sewage, whereafter we are going to try to unveil certain realities that we are facing in the prosecution of these offences by looking at the typical defences raised by accused. And then we're going to conclude and summarize our findings. Okay, so in South Africa, we have 1,235 wastewater treatment works, which is quite a lot. 850 of those are owned by water services authorities, being municipalities. And those systems consist of 3,211 pump stations and also more than 47,000 kilometers of pipelines, just to give an idea of the extent of infrastructure that we are working with in South Africa. 150 of those 1,235 wastewater treatment works are owned by the Department of Public Works, and then around 270 are owned by the private sector. So we are focusing today on our municipal-owned wastewater treatment works. So from the Department of Water and Sanitation's National Green Drop Report and the Progress Reports, which is the most recent statistics that we have, is that in 2022, a number of 39% of the wastewater treatment works owned by municipalities were classified as being in a critical state. They were placed under regulatory surveillance. In 2013, to give you an idea, the number or the percentage of those deemed to be critical was 29%. The vast majority of rural municipalities has a green drop status of less than 50%. It was also indicated that there are growing concerns around the chemicals and antibiotics in the effluents that are not treated or monitored. And in 2023, the risk profile of municipal treatment plants were deemed 34% to be high and 32% to be critical. That's an astounding amount of more than half of our municipal treatment plants being not so run so well and run at a high risk. When you look at the Department of Public Works owned wastewater treatment works, it's also a very, very dire situation. In 2022, 89% were deemed in a critical state. 10 years ago, it was 84%. And in 2023, the risk profile for the Department of Public Works owned treatment plants were 31% at high and 48% at critical. An astounding 79% of treatment plants running at a very, very high risk. Even if you look at in some provinces like the Northern Cape, none of the treatment plants are actually compliant. And that raises the question around, do we really as the government have the necessary capacity to deal with this extent of non-compliance that we are facing? So if you look at the impacts of sewage, they have the pollution and the unlawful discharge has massive socioeconomic and environmental impacts. Sewage failure means that drains are permanently blocked and wastewater flows into residential areas, which poses a health hazard for humans. And this leads to bilharzia, cholera, and hepatitis outbreaks that causes the actual death of people. To give you an idea, currently on an average, 300 children below the age of 5 years die monthly due to diarrhea, which is 100% preventable. Although direct causality between these deaths and the conduct of wastewater treatment works can be difficult to prove, it is reasonable to assume that the reason for infection is due to exposure of polluted water. And if one looks at the statistics of non-functional wastewater treatment works, the possibility to prove that causality seems to become a bit more within reach. The discharge of untreated sewage into watercourses, being terrestrial or coastal, also poses a health hazard to animals, which results in the death of cattle, and that impacts directly on the livelihood of those that are most vulnerable. Unlawful discharge of sewage has also led to the closing of public areas like beaches, and that ultimately impacts on our tourism and our economic activities. What's even worse, in another case related to an agrochemical spillage in the coastal area within the KwaZulu-Natal province, the authorities are trying to rehabilitate the affected area. They discovered then that this area is actually, it contains 100 times more sewage, which is far more lethal than the actual agrochemicals that were spilled. People are left using this coastline, which is Umhlanga and Durban, despite these incredible impacts on human health. Second to the coastal environment, the impacts on subsistence fishers and harvesters of mussels and oysters are also dire. In fact, the toxins biomagnifies in oysters and mussels, which makes it 100 times more toxic. We also have had aquaculture initiatives close its doors as a result of sewage spills. Of course, then, school closures has also occurred as a result of unlawful discharge of sewage. The problem is, once water is polluted, it is not guaranteed that the water quality may easily or quickly be restored again. Not all people understand that water, all water, is part of one cycle. For example, water gets taken out of our natural water resources. It's treated to be suitable for domestic use and for other uses within a town or a city. Thereafter, after the use, it's again then discharged and taken to a water treatment plant that in this instance would be our wastewater treatment works. There it needs to be treated and cleaned because it is again returned into a natural water system from where it will again be extracted for use. So it is plainly wrong to assume that one area's polluted water will never impact on another area. So the sewage situation in South Africa became so dire that the public approached the South African Human Rights Commission on several occasions to request assistance. They then lodged inquiries to determine the root cause of the malfunctioning systems, and they made recommendations on the way forward. So in 2021, they recognized the devastating effects of the sewage spills, and they confirmed that this indeed breaches our citizens' constitutional environmental rights. So they actually recommended that a national disaster be declared. That would allow for the competent authority to issue legislation which allows for far-reaching control and direction, such as emergency procurement measures to get things done. The Human Rights Commission also recommended that a national water care entity must be established to ensure the proper management of wastewater treatment works. That is currently in process. They also recommended an establishment of a beneficiation program to reuse wastewater, the chemicals and the sludge. They recommended that national intervention must occur. That means that the national sphere of government takes over the administration of a relevant municipality. And lastly, they also said that it's now time to hold individuals in power at time of the spillages accountable and to prosecute them. Currently and ongoing regularly, they still receive thousands of sewage-related complaints, and they lodge several investigations. Okay, after that dire picture that I've painted, let's dive into our legislative framework and look at the mandate and the duties of municipalities. So you can divide it into three categories. We're firstly going to look at the public service duties that municipalities have. We're going to look at the mandate to manage wastewater and to be responsible for wastewater within South Africa. And then we're going to go into the environmental duties. Okay, so the public service duties. Firstly, we can start with the Constitution. In Section 2, all obligations of the Constitution must be fulfilled. If you do not act in accordance, your conduct will be invalid. Section 41 indicates that all spheres of government must provide effective and accountable government and be loyal to the Constitution. Section 152 says that the municipalities must strive to ensure the sustainable provision of services, amongst others. Section 195 indicates that the basic values and principles of public administration include, amongst others, accountability, efficient, economic, and effective use of resources, and also responding to people's needs. The Public Service Act and the regulations, they provide the framework for the administration and the conditions of service for the public service as a whole within South Africa. So in terms of this Public Service Act, they published a code of conduct which states that an employee in the public service is obligated to abide to the Constitution and all other legislation, and also to put the public interest first, amongst others. In Section 16, capital A and B, there is even provision made that if you do not act within the ambit of the PSA and the regulations, you can be subject to a disciplinary hearing and also be dismissed. The Municipal Systems Act, in Section 4, again, pulls through the Constitution, says that the constitutional rights of all people must be respected. Section 51 indicates that administration of municipalities must be organized to ensure responsiveness, effectiveness, and there must be an assignment of clear responsibilities. The Municipal Finance Management Act goes into how municipalities must manage their finances. Section 10 and 11 regulates the management of bank accounts. The Act also sets out the roles and responsibilities of officials, and there's a duty to prevent unauthorized, irregular, or fruitless and wasteful expenditure. So that was the public services duties of municipalities. Let's go to the second category, which is the wastewater mandate. So in terms of the Constitution, in Section 156, a municipality has the executive authority and the right to administer specific local government matters. Those matters are listed in Part B of Schedule 4 and Schedule 5 of the Constitution. If you go to Schedule 4, Part B, you will see that water and sanitation services limited to potable water supply systems and domestic wastewater and sewage disposal systems are one such functional area. So it's clear from the Constitution that this is a municipal mandate. The Municipal Structures Act then, in terms of Section 84, indicates that the powers and the functions relating to domestic wastewater and sewage disposal systems are given directly to district municipalities. In terms of Section 84.3, the minister responsible for local government can authorize a local municipality to perform that function. And that is then done by publication in the Government Gazette. And that is typically where the local municipality will then have the functions and the power relating to domestic wastewater and sewage disposal systems, and they will be deemed and authorized as a water services authority. To give you an idea, out of the 256 municipalities that we have in South Africa overall, 144 of them are water services authorities. So it's a bit, it's around half of them are actually water services authorities. The Water Services Act indicates how water services must be managed and given to South Africans. Water Services Authority in Section 1 is defined to include any municipality that is responsible for ensuring access to water services. In terms of Section 11, it is indicated that these water services authorities must ensure efficient and sustainable access to water services. And water services defined, it includes sanitation services, which include sewage removal, purification, and disposal. So it's very clear that water services authorities have the duty and the mandate to ensure that there is efficient and sustainable access to our sewage disposal systems that work and do what they have to do. In terms of 11 sub 5, if there's an emergency situation, a water services authority must take reasonable steps to provide the basic water supply and basic sanitation services, and they may do so at the cost of such water services authority. And then there's further detailed obligations like the development of a water services development plan and so forth. There's regulations in relation to water standards that were published. Regulation 4 of those regulations indicated that where water services are interrupted for more than 24 hours, access to alternative water services, which would include sanitation, must be provided to protect the health of the public. Okay, so that is our wastewater mandate, very clear and very concise. The environmental duties. So if we start again with the Constitution, the right to an environment to be protected for present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation is applicable to municipalities. They have the duty to prevent pollution and ecological degradation. In terms of Section 27(2), the state must take reasonable legislative and other measures within its resources to achieve the progressive realization of each of these rights. So this must be done in a continuous manner to ensure the progressive realization of, for example, the environmental constitutional rights. In terms of Section 41, it is indicated that all spheres of government must secure the well-being of the public. And then in terms of Section 152, the municipalities must promote a safe and healthy environment. So, unlawful sewage disposal or discharges that infringes directly on, firstly, our right to an environment not harmful to our health or well-being, the right to human dignity, the right to sufficient water and food, and also the right to education where schools are then impacted by this. If you look at the Municipal Systems Act, there's also mention of our environmental duties within these municipal legislation. So the Municipal Council must ensure that services are provided in an environmental sustainable manner, and they must promote a safe and healthy environment in the municipality, and then again pulled through the progressive realization of the constitutional rights, beautifully aligned to the Constitution. In terms of Section 73, there's a duty on the municipality to prioritize the basic needs and to ensure that all services are environmentally sustainable. Again, mention of specifically environmentally sustainable services. If you go to the National Water Act, Section 5 requires the Department of Water and Sanitation to establish a national water resources strategy. That strategy addresses everyone's interaction with our water resources, and we have to implement that. The DWS, the organs of state, all other organs of state, and water management institutions must implement this national water resources strategy. And then, of course, municipalities have to comply with all other relevant environmental legislation. And that takes us to our next section, which talks about the typical offences that we associate with our unlawful disposal or discharge of sewage. We can categorize this also into three, being firstly a general duty of care, and then secondly, those offences related to water pollution, and then thirdly, those offences relating to waste. So this would be typically in practice now the offences that are indicated in the charge sheets where a criminal prosecution is ensued. So firstly, general duty of care. NEMA, that is the National Environmental Management Act, Section 49A1E, read with 28. That deals with an act or an omission which causes significant pollution or degradation of the environment. That is our general duty of care principle. 1F relates to an act or an omission that detrimentally affects the environment. So these two are typically always involved where there are pollution caused by sewage disposal or discharge in an unlawful manner. These are punishable with penalties of maximum 10 million rand, maximum 10 years, or both. If you look at water pollution, Section 151 of the National Water Act deals with water pollution, and it says that it is an offence to cause pollution or a detrimental effect on a water resource. Then also, disposal of waste in a manner that can detrimentally affect a water resource is a listed water use in terms of the National Water Act, requiring a water use license. If no water use license was obtained or there's non-compliance to a water use license, that is an additional offence. So currently the National Water Act indicates that these offences are punishable by a fine or 5 years, or a 5 years imprisonment, or a fine or 10 years imprisonment in case of the second contravention, or both. So here, the National Water Act Amendment Bill, which is currently in progress, will align these fine amounts with the National Environmental Management Act fine amounts, being 5 million rand and 5 years. Currently, it's not specified, and that would mean that the Adjustment of Fines Act will come into play in determining the amount of the fine, and that is usually considerably less than our current maximum penalties that we have in environmental legislation. If you go into the coastal environment, now that is where our discharge goes into the sea or the coastal areas, the Integrated Coastal Management Act, the National Environmental Management Integrated Coastal Management Act comes into play. And in terms of Section 69, it is an offence to discharge effluents that originated on land into coastal waters without a coastal waters discharge permit. So if they do not have a coastal waters discharge permit, the municipality, that is typically an offence that is punishable by 5 million rand or 10 years imprisonment or both. And then also a duty of care has been pulled through from NEMA, typically the same as the Section 28 duty of care provision in Section 58 of the ICMA Act. And that would be applicable then if the discharge occurs within the coastal environment. All right, so then if we go on to the typical waste offences, in terms of Section 16 of the Waste Act, the offence would be the failure to ensure that waste is treated and disposed of in an environmental sound manner. In terms of Section 16(1)(d), the failure to manage waste to prevent the endangerment of health or the environment or cause a nuisance through noise, odor, or visual impacts is typically also an offence associated with unlawful discharge of sewage or disposal of sewage. And then sub 1E, in relation to the failure to prevent any employee or any person under the supervision of a certain person, to prevent that person from contravening the act. That's also something that, depending on the circumstances of the case, we can add to the charge sheet. Then in terms of waste management licensing, you would recall that a GA 91, which is the list of waste management activities, explicitly exclude sewage from the treatment and storage waste management activities in relation to hazardous waste. However, the disposal of hazardous waste to land is a general waste management activity with no exclusion around sewage, and therefore where hazardous waste, being sewage, is disposed onto land in a particular case, we usually add this, the fact that they do not have a waste management license, to the charge sheet. However, within the vicinity of the wastewater treatment works, where treatment and storage of sewage is involved, the Waste Act would not come into play. Waste licensing would not come into play in those instances. Another general offence is in terms of Section 26, and that is the failure to prevent the unauthorized disposal of waste. Also a general broad type of offence that we usually add. And that is, all of these are punishable each by a 10 million rand fine maximum or 10 years imprisonment or both. Then you can also add other typical offences, and that would really depend on the facts of the case. Other related offences in terms of the Structures Act, the Municipal Systems Act, the Public Services Act, and the regulations, the Water Services Act, the Municipal Management, the Finance Act, and so forth. So there's actually an endless list of pieces of legislation that can be brought into a criminal matter. All right, so let's dive into the typical defenses that are raised by municipalities when they get a charge sheet and when they are charged for unlawfully disposing of waste and sewage in a manner that is not allowed by legislation. So firstly, and this is one defense that we get so regularly, is in relation to intergovernmental relations. Typically, they argue that before prosecuting, all conflict resolution processes set out in the Intergovernmental Relations Framework Act of 2005 must be exhausted. And also Chapter 4 of NEMA deals with how conflict should be dealt with when there's conflict between organs of state. And they argue that you should resolve this conflict using the Chapter 4 of NEMA mechanisms first. They also say that it's nonsense that the state can prosecute the state. It just does not make sense. They base this view and this argument on the fact that the Constitution actually says that in Section 41 that all spheres of government must cooperate with one another, they must be friendly, they must support one another, they must assist one another, and they must avoid legal proceedings against one another. So they say this is as bright as daylight. You cannot come after us, DWS or DFFE, and the NPA, because we have to work together. You cannot institute legal proceedings against me. So Section 41.3 indicates that if an intergovernmental dispute is applicable, all the parties must make a reasonable effort to settle the dispute before it approaches the court. So first, try everything internally, sit around a table, resolve, and then you can go to a court to try to resolve the dispute. That's what the Constitution says, they argue. Even in terms of the Public Service Act Code of Conduct, it is indicated that all officials must cooperate fully with other officials to advance the interest of the public. And in terms of NEMA Chapter 4, if there's a difference or a disagreement in relation to a power, a function, or the protection of the environment, you are required to work through a conciliation or arbitration process. That's what Chapter 4 says. And the municipalities typically argue that we must follow these processes before we go to court. But the reality is that criminal proceedings are not subject to the Intergovernmental Relations Framework Act. So, if you look at the definition of intergovernmental disputes in this act, it says that it is defined as a dispute between different governments or organs of state concerning, firstly, a statutory power or a function assigned to any of the parties, or an agreement between the parties regarding the implementation of a statutory power or function, and which is justiciable in a court of law. And it includes any dispute related to that matter. So in the MEC for Kokta versus Imbabazane municipality, which is in 2017, in paragraph 3, this court has actually confirmed that the Intergovernmental Relations Framework Act does not apply where there's illegal conduct which requires immediate action. This act, the IGRFA, provides a framework to ensure that there's coordination in relation to the execution of the powers and the functions of organs of state. So its intention is to resolve disputes by using these alternative dispute mechanisms. But it's typically used in civil proceedings, not in criminal proceedings. Criminal offences does not relate to statutory functions or powers or to an agreement in relation to the implementation of these functions or powers as an intergovernmental dispute is defined. So an offence is not a dispute at all. It's not a difference in opinion. It's a criminal offence with dire consequences that are occurring. Furthermore, the National Prosecuting Authority is the institution that prosecutes. They decide ultimately whether or not they want to prosecute, and they run with the prosecution. So if you look at the definition of organ of state in terms of section 239 of the Constitution, and that's also pulled into the IGRFA Act, That organs of state definition excludes the courts and judicial officers. So in terms of Section 2 of the RGRFA Act, it further indicates that this Act does not apply to courts, judicial officers, and any other constitutionally independent institution. So this means that the NPA is not required to follow the RGRFA's internal dispute resolution mechanisms, because it's criminal offences, it's serious matters that we're dealing with. In terms of NEMA's applicability, Chapter 4, the question can be asked, is an offence a difference or a disagreement in terms of functions or the protection of the environment? Is there a disagreement around this? No, it's an offence. It's a criminal offence, and that warrants that criminal prosecution can be pursued. Okay, going on to the second type of defence. So they usually argue, but listen, it's not only our responsibility. The provincial sphere of government and then also national governments had to help us because we have limited funds, and our duty to provide a safe and healthy environment is actually qualified. It's not an absolute duty. They argue that Section 152 of the Constitution says that the municipalities must strive to achieve their objectives, but within their financial and administrative capacity. Section 154 of the Constitution places an obligation on national and provincial government to support and strengthen the capacity of municipalities by legislative and other measures, and to manage their own affairs, to exercise their powers, and to perform their functions. So there's a duty, they argue, on national and provincial governments to support and strengthen the capacity of municipalities. And then Section 139 of the Constitution provides for a process of provincial intervention where a municipality does not do what they are supposed to do by issuing directives or assuming responsibility for certain obligations. If that provincial intervention does not work or not happen, then national would intervene. And that is why they say, listen, but provinces and national never helped us. And now you are wanting to prosecute me, but why not go after province and national as well? In terms of Section 63 of the Water Services Act, this is typically the same as Section 139 of the Constitution, where there's the provincial intervention. And then when there's unsuccess, where it's not working, the minister can typically assume responsibility for a water services authority is responsibility where they do not perform their functions effectively. But the reality is the required support does not alleviate municipalities from their duties. These duties include, like we indicated, accountability, efficient, economic, and effective use of resources and responding to people's needs, to place the public interest at the forefront, responsiveness, effectiveness, the assignment of clear responsibilities, and also, of course, adherence to legislation. Then further, in Section 151, sub 4 of the Constitution, the status of municipalities are actually constitutionally protected. It indicates that the national or the provincial government may not compromise or impede a municipality's ability or the right to exercise its power or perform its functions. If you look at provincial administration, this has been tried in the past. Since 1997, there were 142 invocations of Section 139 interventions, so that averaged out on 7 per year, but several repeat interventions still occur. So municipal performance, if you look at what's going on today, it remains far from optimal. So that raises the question, is this really effective? Does it help? However, that all said, in a recent case in 2023, the court actually said that, listen, provincial government, you actually had the duty to intervene. So yes, we can argue that it's not necessarily effective, but the provincial government and also national government shouldn't just sit back and wash their hands. Of course, it will require a factual inquiry. Firstly, did the municipality go on for years and years struggling, or did they go and ask for help from the province or from the national department? Then, did the province try to assist, and did the municipality comply? Did they get money? What happened to that? And then also, was the national intervention requested? Was it done? And then what happened thereafter? So the facts of the case will always depend. Will decide on what is actually the resolution. I want to pause here and hand over to Liesl. This is also in relation to the second offence, saying that provincial and national interventions were required. And this is just specifically asking the question from DW side, WS's side, the Water and Sanitation Department, of whether it is practically possible for them to take over a dysfunctional municipal wastewater treatment work. Liesl?
Thanks, Lisa. The short answer to the question is, of course, we can take over. Is it practically implementable? The short answer is actually no. Let's just interrogate this a little bit. If you take over a municipality in terms of Section 63 of the Water Services Act, the minister raises the issue. He then has to get the Minister of Cooperative Governance of COCTA to join him in then indicating to province, look, here's a situation with the municipality, and request provincial intervention in the matter. So that being done, you still need a provincial government to support, once this is tabled, at provincial government, at the NCOP, to then approve this application, and the minister can then step in and take over part of the WSA's function. That process is actually the easy part, in inverted commas, of the process. What is the problem that we're experiencing currently is, if you look at the diagram, you'll see the water services budget, the water services income that's coming in from water services charges and sanitation charges at the municipality levies is not separated or ring-fenced in order to allow the minister to take over part of the function, because in reality, you're only wanting to take over the wastewater treatment works and the water supply function. But that currently is a problem that we've highlighted with Treasury, in that all the income coming through to the municipality, SEM, HR, all the revenue is in one basket, for lack of a better term. So the minister can't then step in and, practically speaking, take over the function because of the setup of the budgetary constraints within the municipality. Treasury has seen the light of this problem, and the engagements currently with Treasury, I don't know what the end result will be, but they're beginning to understand that water and sanitation budgets need to be ring-fenced or set aside, or budget set aside, that it doesn't then get taken or diverted to pay for other functions within the municipality, because that's what's at the end of the day affecting operation and maintenance of the wastewater treatment works. So in essence, we can, but practically speaking, it is an issue. Thanks, Lisa.
Thank you, Liesl. Okay, going on to the third type of defense. Basically, always they raise this, that they have no resources, they have no money, they have no human resources to properly manage and maintain the infrastructure. Also arguing that our funding model does not allocate sufficient resources for sanitation. They base this argument on Section 152 of the Constitution, which says again that municipalities must achieve their objectives, but it's qualified. They must strive within their financial and administrative capacity. And how can they do that if they don't have the finances and the human resources to properly maintain and manage the infrastructure? This problem is exacerbated by the fact that currently 47% of all water that is pumped into South Africa for use is non-revenue water due to illegal connections and leaks. It's actually shocking that this happens. So they are actually running at a loss, the water services providers. And then, of course, climate change causes extreme weather events, and this leads to flooding, and that also impacts poorly on the impacts highly on the poorly maintained infrastructure. So it's a very, very complex and difficult problem to have currently. However, this is not a sufficient justification for the infringement of citizens' constitutional rights. So the fact that it is not a justification for infringement on rights was confirmed in the Msunduzi case and the Rand West case. I did indicate there at the bottom of the presentation all the full citings of these cases. Lack of finances can never legitimize illegal activities. However, at best, they can be used in the mitigation of sentencing. So in terms of Section 153 of the Constitution, the municipality has the duty to structure and manage its administration and budgeting and planning processes to give priority to the basic needs of the community. So they must ensure that their administration and their budgeting and their planning must prioritize basic needs of the community, and that would include water and sanitation services. A factual inquiry will also will also inform the response. Looking at the allocation of funding, what happened with that, where was it spent, was there anything lost? And also then again, did the municipality go on and struggle for years and years onwards without approaching the province or the national government to assist or support and ask for support as required by the Constitution? Okay, the fourth defense is that it is nonsensical to hold organs of state criminally liable, arguing that the law is not binding on organs of state insofar criminal liability, stating facts that municipalities as a person cannot be prosecuted, convicted, and punished. And it's absurd to interpret the law so that all organs of state can be prosecuted. They argue that because there's no provision in NEMA which binds the organs of state insofar any provision in terms of this act, although the Waste Act and the Water Act explicitly binds the states, but that is only in relation to the functions and the powers that they should execute. If you look at the State Liability Act, that deals only with civil liability and not criminal liability. And even in the international realm, the ICC, the International Court of Criminal Justice, does not even prosecute organs of state. They only prosecute individuals. So how can we then hold organs of state criminally liable? The definition of organ of state in the Constitution, they argue, are way too broad. That includes the presidency and the office of the Chief Justice. So how on earth can you actually then criminally charge the presidency? It does not make sense. So there must be some sort of wrongdoing here. If you look at Section 34 of NEMA, that is the criminal liability provisions, the criminal proceedings. The intention of this provision was to hold individuals or corporations liable and not organs of state. If you look at the wording, you will see that it's worded as, the private sector, looking at individuals, terms like the firm, director, employee, employer are used. So there's no indication that it was ever the intention of the legislature within the NEMA regime that organs of state should be criminally liable. But the reality is that public interest requires municipalities to be held criminally liable due to the fact that there's infringements on constitutional rights, as we have established. Section 48 of NEMA, that was repealed in 2013. That provision said that this act is binding on the state, except insofar as any criminal liability is concerned. That was repealed 11 years ago. The intention of this repeal was to indicate that organs of state can attract criminal liability. If you look at our Constitution, Section 9, everyone is equal before the law. It's included in our Constitution. There's no indication that organs of state are absolved from being held criminally liable and cannot be criminally prosecuted. The Interpretation Act, so that is an act that we use to guide our interpretation of legislation. That defines the term person as being any divisional council, municipal council, village management board, or like authority. So that includes those type of councils So therefore, if the word person is used in legislation, like it is used in our environmental law, that must include municipalities. Actually, and this was also indicated and confirmed in the Msunduzi case, organs of state need to be held at a higher standard in relation to legal compliance because they should lead by example. They are providing services that impact directly on the public at large. And that was confirmed in judicial precedent. It was also confirmed in the Msunduzi case that our enforcement action in response to non-compliant organs of state that impacts directly on our constitutional rights must be stringent and taken swiftly. And it was also based, and this is also based on the fact that sewage pollution is an ongoing, serious, prevalent crime, and it is extremely dangerous, resulting in the death of people and animals. And then there were recently 3 big criminal cases, successful convictions, where municipalities as organs of state were successfully prosecuted. And that is firstly State versus Rand West local municipality, State versus Thaba Chueu local municipality, and then this year, the Govan Mbeki local municipality criminal case. So I'm going to go through a brief explanation of the facts of this case to give an idea. So 2022, the Rand West local municipality, what happened here? There were ongoing unlawful discharge of untreated wastewater into watercourses. Between 2013 and 2022, manholes overflowing, cattle died. They had a water use license, they did not comply therewith. There were poor maintenance of infrastructure, and therefore there were ineffective operation of the wastewater treatment works. The municipality also failed to monitor compliance with effluent standards that was included in their bylaws by the surrounding facilities who actually discharged their effluent into the wastewater treatment works. So directives were issued to this municipality, but the municipality just said, sorry, we do not have resources. So the DWS then provided funding for repairs, but the unlawful discharge then just continued. They didn't approach the DWS again to maybe ask for exemption from their water use license. So then criminal prosecution ensued, and they were charged on 2 counts. A plea and sentence agreement in terms of the Criminal Procedure Act was made an order of the court, where the municipality was fined a 10 million rand fine. 7 million rand of this was suspended for 5 years on condition that no similar offences are committed. 3 million rand was to be used to effect repairs, and proof of those repairs effected must have been submitted to DWS and the DFFE. And then also technical expertise and bylaw enforcement officers had to be appointed, and there was additional processes that they had to install in the operational process of the treatment plant. So this is the Rand West local municipality. The Thaba Chueu local municipality last year in Leidenburg, sewage problems has been experienced for more than 10 years due to a non-functioning wastewater treatment work. Sewage pump stations and manholes overflow daily. There were basically sewage rivers and wetlands that were created so close to communities. Raw sewage were dumped into the rivers that flows into the Kruger National Park and Mozambique as well. So several dockets were opened and registered by the police service and our environmental management inspectors based on sewage and waste. They combined everything, they finalized the criminal investigation, and they charged this municipality on 7 counts. They confirmed and they reached a plea and sentence agreement. They were fined with a 10 million rand fine. 5 years of that was suspended for 5 years on condition that they do not commit similar offences. That was in relation to 3 counts. For the rest of the counts, 5 million rand was issued as a fine, wholly suspended. Indicated that 4.8 million rand had to be utilised for repairs within a specific time frame. There were reporting requirements to the authorities. DFFE is the Mpumalanga Environmental Department. And then also it was indicated that 200,000 rand had to be paid equally to DWS and DFFE for the investigation and prosecution costs. That's in terms of section 34.3 of NEMA. So that was the Thaba Chueu local municipality. Govan Mbeki local municipality in Secunda, this was a month or 2 ago. What happened here? Basically the same sort of facts. There's a lot of these type of cases that's ongoing now. So, unlawful discharge of untreated wastewater into several resources between 2019 and currently. The water quality in the area was actually classified as toxic. The wastewater treatment work is in a complete standstill due to vandalism of essential infrastructure. There's no people on site. Although they submitted a rehabilitation plan in 2020, they did not implement that. So criminal prosecution ensued. They were charged on 6 counts. A plea and sentence agreement was reached and made an order of the court whereby a fine of 200 million rand was imposed. 50 million of that was suspended for 5 years on condition that no similar offences were committed. The plea and sentence agreement indicated that 150 million rand actually had to be utilised for urgent repairs that were identified. Proof of that repairs must be submitted to DLIA and DWS. Then 350,000 rand must be paid to DWS and DLIA each, and that must be used for EMI capacity building. And then also requirements in relation to appointment of technical experts, supervisors, installment of pre-treatment processes had to be done before a certain time period and proof thereof submitted to the authorities. Monitoring requirements in terms of effluent standards for receiving wastewater and water leaving the wastewater treatment work is included, and then also external auditing requirements. Okay, so that was what the court ordered in that case. Okay, let's go to the 5th defense. They argue that we actually charged the wrong municipality, saying that no, it's not the local municipality that is at fault here, but the district municipality. They base this on the fact that the Municipal Structures Act confirms that the mandate for domestic wastewater and sewage disposal systems is actually on the district municipality. So you shouldn't charge the local municipality, you should charge the broader and the larger district municipality. And also, the district municipality approves new developments in areas that would require wastewater treatment work infrastructure, but then they do not consult with the local municipality, who is the actual water services authority. So how on earth can you hold the local municipality? How can you charge them? So the reality is that if the local municipality is designated as a water services authority, it is responsible for the wastewater treatment facilities. So you would recall Section 84 of the Municipal Structures Act gives the power to the minister to authorize a local municipality to take over a function or a power, so they can become water services authorities in terms of the Water Services Act. And 144 of them are already. And water services authorities are responsible for ensuring access to water services, and that includes water supply and sanitation services. So they have that duty. And then again, judicial precedent exists for convicting, and all 3 of these cases that I discussed just now were local municipalities. So that also in our favor, it's indicated that if there are water services authorities, they have the responsibility. A factual inquiry will always be required, looking at which municipality was operationally responsible for the dysfunctional infrastructure. And also, during the preceding enforcement proceedings, the meetings and so forth, did municipal officials at any stage explicitly admit that or take responsibility or say that they will effect the repairs? So you will always look at the facts of the case when you determine who to charge. Okay, the 6th defense, saying that it is irrational to punish convicted municipalities. How can you punish a municipality? Because the penalties upon conviction is aimed at a person and not at an organ of state. So penalties are usually fines or imprisonment. So who ultimately pay the fines if we impose a fine on the municipality? I give you 3 guesses, and that is the taxpayer, we who pay our rates and taxes. So we cannot close down a municipality due to services that they render. So, I mean, that also is not a solution. And we can also not imprison a municipality. So it's really not, it does not make sense. That is how they argue. It's not sensible to charge municipalities, because how do you actually punish them? The reality is, however, that as we've seen with these these 3 cases that I've discussed, that a structured fine is now imposed linked to obligation. So we get creative with the sentencing. We request the court to impose a fine with instructions on how it should be spent. And then, for example, it must be spent towards urgent repairs and necessary repairs of identified infrastructure. We indicate that they should appoint technical experts. It's usually limited to time frames. There's maintenance plans and repair plans that can be submitted. We include regular reporting obligations in terms of expenditure and process. However, this order can seem beautiful on paper, but it remains ineffective if we do not ensure and monitor compliance to these orders and enforce compliance to these orders. If you look, for example, at Government Mbeki, like I said, they had to effect necessary repairs before a certain time frame. They had to submit reports in terms of what they did and where they spent their money, and also appoint technical experts. Taba Cheu, same thing. They had to effect urgent and necessary repairs before a certain time frame, reporting requirements as well. Rand West, same thing. Urgent and necessary repairs before a certain time frames, proof and reporting and external requirements, external auditing requirements were also included. But my question is here, is it enough to stop here when we are trying to solve the problem? Because, like these 3 cases, the sentences imposed remains largely suspended. So who really feels these penalties? The punitive aspect is lost. And I mean, the aim of criminal prosecution is punishment. It's not necessarily to try to rectify the situation. For that, we have administrative enforcement as well. But the punitive aspect of the criminal proceedings in these cases are being lost, it can be argued. So the Taba Cheu municipality case, 5 million rand was suspended. And then again, 5 million rand wholly suspended on certain conditions. Rand West, 7 million rand was suspended. Governor Mbeki, 50 million rand was suspended. So what would the alternative be? And that is lifting or piercing the corporate veil. We must not stop at trying to prosecute and get fines and convictions against municipalities, the organs of state, but we must go further into the liability of officials. And in terms of this, we also, of course, get a lot of defenses. Like, for example, individuals here are charged only by virtue of their official capacity, but they didn't themselves commit the crime. And an additional argument is that, to prove unlawfulness, you must prove intention and not an omission, which is generally the case. They argue that intention always needs to be proven, and we usually rely on negligence. All our offences are drafted in a manner that says failure to, which is an omission. Individuals were in no way personally involved in the discharge, so it was not their responsibility to physically manage the wastewater. They don't know what happened on site. They were not there, and so forth. So that's what they argue, and their defense usually are. They say that in our charge sheets, we do not specify what the reasonable measures is that they had to take to prevent this pollution from occurring in that duty of care offence. They also indicate that our charge sheets lack the tasks of individuals. What is it actually that they were responsible to do? Ultimately, they are saying that we are now trying to prosecute individuals for a collective failure of government. But the reality is that our legislation actually allows for the prosecution of all guilty parties in their personal capacities. Let's start with the Municipal Systems Act. Section 51 says that the municipal manager must be held accountable for the overall performance of the administration. 55, the municipal manager is the head and is responsible for effective, efficient, accountable administration, management of the provision of services in a sustainable and equitable manner, implementation of national and provincial legislation, and all income, expenditure, all finances of the municipality. Municipal councillors and all staff members must abide to the code of conduct. So actually, all of the officials employed by a municipality has a duty to adhere to the legal framework applicable to them. The Municipal Finance Act indicates that the municipal manager is the accounting officer and must act in accordance with this act. Section 32 indicates that that accounting officer is liable for unauthorized expenditure deliberately or negligently incurred by the accounting officer. It further indicates that any political office bearer or official of a municipality who deliberately or negligently committed, made or authorized an irregular expenditure is liable for that expenditure. This net is cast broad. Any political office bearer or official of a municipality, again, that made or authorized fruitless or wasteful expenditure is then liable for that. Section 61. The municipal manager can delegate any power to another official. So then again, we must go further into the investigation and go look and determine, okay, but what delegations were made to whom? And was there maybe a power in relation to the wastewater treatment works or the funding thereof or something that were delegated to that relevant official? And was that duty fully executed and sufficiently executed? If we go into the environmental realm, our Environmental Management Act, NEMA, says that in Section 34(7), it confirms that directors can be held liable. Directors, if they fail to take reasonable steps, all necessary reasonable steps to prevent the offence from recurring. Director in this section is defined to include those persons responsible for the management and affairs of a corporation. So that would include senior employees, managers, executive directors, and non-executive directors. So basically anyone in charge or responsible for managing a corporation. A firm is broadly defined as a body incorporated by or in terms of any law, as well as a partnership. So that would include a municipality. NEMA goes further into casting that net of personal liability extremely broad by providing in 34(5) for vicarious liability of employers, indicating that the employer, that would be now the senior manager or the actual municipality itself, can be held or can be guilty of the offence if a manager, an agent, or an employee commits an act which would be an offence for the employer to do, and also if the employer failed to take all reasonable steps to prevent that act from occurring. And then if you go into Section 34(6), it says, it turns it around, and it says that employees can be held criminally liable as if they were the employer, as if they were the municipality themselves. If they did something that were their task to do, or they refrained, or they did not do something that they had to do on behalf of the employer. So basically, NEMA casts the net very broad in terms of environmental contraventions, saying that municipalities, firms, corporations, and also senior managers, being the municipal manager, and anyone who had to do something on behalf of the municipality that had the task to do something, if they did not fulfill that duty, they can be held personally, criminally liable. So we have the legal ground to hold individuals liable. So the elements of an offence is an act, unlawfulness, causation, liability, and fault. Broadly, we get two forms of fault, so intention and negligence. If you look at the wording of environmental offences, we have included references to intentionally or negligently committing those offences. So therefore, we argue that negligence is sufficient to be proven. However, in the Ngwenya case in 1979, it was indicated that the default position is that intention must be proven, but there are exceptional circumstances. So firstly, if the legislator can be regarded as requiring a high standard of care for the activity, or if the legislation is directed against a dangerous and a prevalent social problem. And that second one is where sewage-related offences would fall within. We know that sewage discharge, unlawful sewage discharge, is a dangerous and a prevalent social problem currently. Therefore, it is sufficient to prove negligence as the form of fault in these cases. So a factual inquiry will also be required in terms of determining who to hold liable. We have to set out an organogram indicating the tasks at the time of the commissioning of the offences of the individual. We must verify compliance with the duties, follow the paper trails, look at monitoring, look at maintenance that were done. And line function officials should also be prosecuted. This is, however, made difficult by the high turnover that we currently have in municipalities. Then the last offence that we usually raise that we're going to discuss today is that we did not indicate any proof of the actual pollution levels. So we did not submit evidence of unacceptable pollution or harm that was caused by the sewage discharge. They argue that we cannot simply allege there was a breach of Section 24 of the Constitution. We need to prove the unacceptable levels of pollution or harm to succeed in our prosecution. The reality, however, is, although it is always favorable, and we need to try to get that information, proving unacceptable levels of pollution is actually not essential. So the elements of an offence must still be proven. In the Msunduzi case, the court actually found that the fact that no scientific or medical evidence was provided to establish unacceptable levels of pollution was not a valid defence by the municipality. That court reasoned that the constitutional environmental right is actually not so technical anymore, it's more sociological. It's a right to a healthy and a balanced environment. So there's no need for us to go into extreme technicalities by getting the exact pollution levels. We must look at whether the healthy and the balanced environment, the constitutional environmental rights within a sociological sense, were infringed upon. There's a duty of care, a general duty on the state to protect the environment in terms of the Constitution. Therefore, it's not essential to prove that the activities was actually harmful to his or her well-being. Okay, and then I'm going to give over to Liesl again to discuss from DWS's viewpoint what they are busy doing in terms of the sewage situation of South Africa. Liesl.
Thanks, Lisa. Okay, it's a very bleak picture Lisa's presented. Let's see what positives the DWS has been up to over the past 24 months. For those of you that might know, we've undergone an extensive period of law reform. Lize has raised a number of defences that have been raised by municipalities, and that's what our EMIs are encountering from a CME perspective when they opening up criminal cases against municipalities. So one of the holes that we are trying to close, and we should remember that compliance monitoring and more so enforcement is a measure that you're actually wanting to, what's the word? You're wanting to punish the transgressor. But punishing, as in the cases that Lisa's raised earlier and the examples that she's given, ultimately doesn't fix the works. You get a court order like we've gotten now, Govan and Mbeki, and you see the majority of the court order, the 150 million that we cited, was to go towards actually implementing the upgrades to the works that's needed. But together with that, what we've seen is that the expertise, the competency required by those water services, technical managers, your process controllers on site is not there. So what we've done is last year we published Water Services Amendment Bill and of course the National Water Amendment Bill. You'll notice that the Water Services Act was promulgated in 1997 and the National Water Act in 1998. So this is the first set of, we have lagged behind, the first set of amendments to the Act. We're trying to bring out a minimum competency requirements for water service providers so that you can get the correct expertise at the works to make it run efficiently. bearing in mind the works only has a certain limit that it can take. Fixing a works, getting it to the right standard, and then allowing another development to come out, and the maximum capacity of the works is then exceeded, doesn't help even if you have the correct expertise on site. So these are all the gaps that we are trying to close with the amendments that we're bringing in. So you have minimum competency requirements, a new section 22A to D. And then, of course, in terms of the Water Services Act, there aren't and haven't been any enforcement powers in the Water Services Act. So you can see it's quite necessary for us to have made this amendments to the Act. So we've introduced directives so that we can issue directives to the WSI when it's not fulfilling its obligations. And then, of course, where there's persistent non-compliance with directives, the minister may rectify these non-compliances, basically an execution of works type example, where we then step in as DWS, which should always be the last resort. Lisa, thanks. If you could go to the next slide. This is just a pictorial explaining for the next, I'd say 12 to 18 months, what DWS is going to be doing in terms of the law reform process. We've now already promulgated the amendment bills. We now have to set up the licensing regulations and, of course, get certification of all of these bills past the Chief State Law Advisor, which in and of itself is a massive thing to do. And one of the defenses that was raised, and another stumbling block that's being raised again with these amendments, especially in terms of the Water Services Act, is the ability of national government to hold a municipality that is a WSA in terms of the license. They say we are stepping into the realm and knocking against the constitution of cutting out a certain WSA, because we are saying a WSP now needs to fulfill certain requirements. We are going to be licensing that function. And if you do not meet those requirements, we will then issue you with a temporary license, and you basically need to work yourself up to a status that you then get various phases of these licenses coming through. And it will all be performance-based. And what we are encountering now is that the Chief State Law Advisor sort of said, constitutionally, we need to be very careful because you are trying to tell us what a WSA should do and be, which is really within the realm of COCTA. So there are a few changes that are going to be coming, and hopefully we can get certification of these bills. Thanks, Lisa. Also, in terms of the Section 9 and 10 of the Water Services Act, we have published amendments to the compulsory national minimum norms and standards. So you know that the municipality needs to comply with SANS 241. They need to comply with effluent quality standards. They also need to comply with their monitoring that they should be doing and aren't consistently doing. Which is reflected in the Green Drop reports that have been published. We've updated the minimum norms and standards for provision of water services. There have been numerous changes. Some of the amendments include that we're moving away from household connections. We are moving away from further connections that can't sustain the water and wastewater system. So when you start with a new development, and this is something that we discussed with DFFE last week, a WSA is ultimately responsible for the wastewater treatment works. But you have a local municipality issuing approvals for new developments to developers, and they then want to get connected to the systems of the municipality. Those approvals are all given at the local municipality level, and the WSA is none the wiser. So what we're trying to say is at this point in time, you have to tell developers or further household connections that are then coming in through these developments, those need to be catered for off-site. If the municipality system can't sustain it, it's already overloaded, these wastewater treatments would have to be then built as part of the development and be off-site. Further water conservation and demand management plans have really been elevated, and the municipalities have to comply now with these national norms and standards that have been published. Professionalization of the water services management is an extremely important task when it comes to those that are managing the wastewater treatment works. As I've said, we've prescribed the minimum qualification requirements. We've also had engagements with MISA because prescribing these minimum standards and competencies means that municipalities have to employ certain officials with certain qualifications. So MISA's training would have to be amended, and we would then have to work closely with MISA and COCTA in order to change these job profiles. And this is a mechanism to basically force municipalities to employ competent and qualified officials in order to manage the works. Thanks, Lize. So these are the further amendments in terms of Section 10. As you know, the municipality can't generally deviate from the norms and standards that national government sets in terms of the tariffs. At issue here is the problem municipalities are experiencing. They often cry, well, national government, you haven't given us enough money, you haven't supported us, I need to build or rebuild my works, it must be upgraded. But part of the problem is that municipalities are not effectively collecting their revenue. So you do have, and in fairness to municipality, they also have issues of illegal connections, people not paying their bills, but they also empowered to hire, for lack of a better word, credit management services to collect their bills, to ensure that their payments are coming through. And I don't know if many of you can recall, last year Tshwane was cutting off everybody's water supply because of the amount of the accounts that are outstanding. So revenue collection is something that sits solely within the realm of the local government sphere, and more attention should be paid to these management services so that they can ensure a secure form of revenue coming in. And also, we are now trying to force them to use the revenue that comes in for not only ring fencing it via treasury amendments, but to ensure that the O&M of the wastewater treatment works actually gets done from the revenue that's coming in. Thanks, Lize. Something that the department is also currently busy with is we're wanting to name and shame polluters. We're wanting to publish a national polluters register, which would be a database with all the names of polluters in the country. It's something similar to what the EPA has in America. And we are setting out the framework for the criteria for those that will be put onto the National Polluters Register. Of course, there are POPI considerations and things, but it's something that the minister is really driving within the department. Thanks, Lize. One of the other avenues that the department is pursuing in terms of the sewage problem is that it's been elevated to the Deputy President and Operation Vulindlela. For those of you that don't know what Operation Vulindlela is, it's a special purpose vehicle that's situated within the presidency. So the main aim is to highlight key sectors, electricity being one of them, and we're wanting to put water and sewage on that same platform. So the presidency via Operation Vulindlela can speak to the role players at that level, be it local government, provincial government, and treasury, to unlock areas where we are hitting our heads against. And that is what our DG is currently busy with and has made numerous presentations in this regard. Key policy questions to be asked. There is sufficient financial and non-financial support to municipalities. DWS has been enforcing its regulatory actions. You can see from what Lize has mentioned earlier, there are numerous court cases, etc., etc. It's been elevated. You'll see a slide later on in the presentation. I think we have about 72 criminal cases that are currently running against municipalities. We have about 22 civil actions against municipalities. So a lot is being done. Is it amounting to change on the ground? Basically, what Lize has asked earlier on. Why is the sewage situation still worsening? And you can see there, we've said that the answer is no to these questions. There is a structural problem, a fundamental reform, which is seated within local government that needs to happen. And that's the cry we've been making to National Treasury. It's the cry we've been making through Operation Vulindlela. We're following all the processes, be it criminal, civil, support, and remember DWS wears two hats. We have to support municipalities, both financially and via other forms of support, training, sector-driven support. But then nothing seems to be changing. So the IGR complaint that was raised earlier by Lize is still being raised by municipalities without them taking on the serious need for change. So structural, fundamental reform of local government is what we're saying is needed. And you can see the role players extends not only to the Department of Water and Sanitation, it's the collective of Treasury, COCTA, and Human Settlements. Thanks, Lize.
Thank you, Liesl. Thanks. So in conclusion, Sham, I don't want to dishearten you. It is a bleak picture that we painted. But the reality is that our sewage offences are at a critical level. Like Liesl said, we have as sister departments pending cases against municipalities, 38 from our side and then DWS 72. The environmental and the health risks have been established of unlawful sewage discharge. And it has been confirmed that amongst others, the constitutional environmental right is being breached by this. But the message that I want to get across, part of the message is firstly that our legal framework is substantial. Our current legal framework actually allows for the securing of convictions against municipalities and individuals. We are able, and it's a work in progress, but we are able to rebut the defenses that's being raised in these cases. And the dire situation that South Africa's water management currently is in relation to sewage just justifies the fact that we cannot be technical and lose sight of the big picture. It is essential that we actually take enforcement action, stringent enforcement action in the form of prosecution against these individuals and against municipalities. So our current legal framework is sufficient. It does allow for the securing of convictions that we get, but there are always room for improvement, like, for example, what Liesl spoke about now. But like I said, the time has come for a zero tolerance approach that needs to be taken. We must lift that corporate veil. We must impose sentences that are not suspended anymore, and we must convict individuals that are responsible and criminally liable, and we must sentence them to imprisonment when necessary. I'm afraid that's the only way in which we will get the message across and get that punitive aspect back. And where we get the punitive aspect back, I'm sure that we will get and we will see a big change in officials' thinking around their duties and the implementation and the execution of their duties. Thank you. That is all from our side.
Thank you very much, Lisa and Liesl. Before I say too much or comment on your presentation, let me rather hand over to Mishka to conduct the Q&A session for us, and then we can all provide either questions or comments on your presentation. Thanks.
Okay. Thank you so much, Dr. Erasmus, and thank you to our presenters, Mrs. Liesl and Lisa. I think like your discussion has been really thought-provoking and very insightful. I think I speak for all of us when I say like you've given us a really comprehensive view of South Africa's sewage challenges and the law relating to it and the defenses that municipalities typically raise and that we also complain about sometimes. So with all of that in mind, it is now time for our Q&A. You are welcome to pose your questions or comments in the chat, and you can raise your hand to pose your question verbally after you've unmuted. But since I have the mic at the moment, I'd like to use this chance to ask my question first. So I hope you guys will forgive me. So yes, my first question, it's posed to both of you, and it's more of a probe. You know, we see the new developments, or the new amendments in the bill, which look really good. They look very promising, but we know and we've seen local governments' track record in keeping with these. My question, though, is when we see these cases in courts against local government, how often do we give local government a chance, or do we pose the option to local government to put their cards on the table and to tell us what they can actually manage in terms of water and sanitation with relation to their limited resources or their capacities or lack of skill? So that is just the first question. And would that not be a better way of getting them involved and holding them accountable for the services that they need to provide, because then they sort of start setting the pace for recovering or rehabilitating our water and sanitation or sewage services. And my second question is the new developments where you mentioned that we have limited space in terms of developing sewage reconnections to new developments and things such as that. But it's also known that, you know, our water or traditional sanitation systems is very water intensive. It has a very big impact on our current water security and our current water load. We have a very scarce amount of water. Would it not be prudent or better for not just the new developments, but to consider ways in which we have sanitation systems and new developments with less water intensive sanitation or toilet connections? That is just the question that I'm posing. It's not necessarily a must. And I'm saying this very tentatively, considering South Africa's history with access to sanitation and flush toilets being so entrenched or so part of our inherent dignity as people. So yeah, those are just my questions. You can respond to those, or we can take 2 hands from the audience to pose their questions. So we can ask Melissa and Prof. Oliver Fuo, and then you, the presenters, will have a chance to respond. Okay, Ms. Melissa Strydom, you are welcome to open your mic and pose your question.
Thanks, Mishka. Thank you very much, Lisa and Liesl. That was certainly very illuminating. And it is very interesting to sort of see those defenses articulated. You know, obviously in practice and in academia, people theorize a lot around these defenses. So it's really useful. And I sort of want to emphasize, like, don't underestimate the value of, you know, sort of putting out that information into the public space, because it's extremely useful, you know, for practitioners and academics and the general public to have the insight that you share, because it's not something that's readily available. it would be absolutely amazing if that could be published in some sort of journal write-up. Sorry, that's sort of just the prelude to my question. But sort of flowing from that, you know, the deterrent value of criminal sanctions really relies on people being aware that these prosecutions in fact take place. And because both of you are probably very immersed in this, that to you probably seems like a no-brainer, like surely people should know, you know, it's part of your daily lives. But, you know, in researching criminal sanctions and criminal enforcement generally, aside from the NASA reports and the odd plea and sentence agreement, you know, floating about, you know, it's a major concern that there isn't a publicly accessible database. I've noted you mentioned the register of polluters, and that's all good and well, but I really think there's a significant value in having more information, you know, publicly available in terms of concluded prosecutions. So the charge sheet, the sentence annexure, or the section 105A should be captured somewhere in a database. Currently, the information in the NASAs are very limited, and not many people see that. So I sort of, you know, I'm just asking in terms of, in addition to the National Polluter Register, now, is there perhaps considerations of putting these documents up? I mean, I'm pretty sure that the concerns under POPIA fall away and there are exclusions once there's a conviction. So to me, having the detail around those cases, like other than asking for that information from the sources, from prosecutors or from EMIs, you know, I've struggled to get them. I have to like beg, borrow, steal, plead to get section 105A agreements. And often, you know, you're lucky if it's shared, you know, by a journalist. So, you know, and the devil really is in the detail. So in addition to the value to practitioners of having that information in academia, you know, I think there's also a lot to be said for the deterrent value of that level of detail reaching the public domain. I'd be very happy, you know, grateful for your comments and insights on that. Thank you.
Thank you, Ms. Redom. Prof. Flo, you're welcome to pose a question.
Thanks for the opportunity, Mishka. Can I suggest that the presenters should respond to those comments and questions before we proceed, so that there are not too many and probably confuse them?
Okay, we can do that. Ms. Lize and Liesl, you are welcome to respond to the questions.
Thank you. If it's okay with Liesl, I'll go first and then she can jump in. So yeah, Mishka, thank you for your question. In relation to your question around taking the municipality's side and what they are able to do and what not into consideration, 100% I agree with you. That is extremely important. Otherwise, what is the value in having these convictions and these instructions, but it's actually not implementable and it's not then enforceable? So all three of these significant cases that we've discussed, or the convictions, are in the form of plea and sentence agreement. So usually how that works is that the accused then says, okay, we agree that we will plead guilty. And then there's a process where the prosecutor, the competent authority being DFFE or DWS, sits down with the municipal representatives, and they come up with the actual text and the content of this agreement, saying yes, we will plead guilty and we will be able to do X, Y, and Z by this time, do this type of reporting, do these type of external auditing, and so forth. So that opportunity is there for them to provide their side and their input. So I think also in terms of a general prosecution and conviction, usually the court would always just go reach a verdict on whether they are guilty or not, whether the accused is guilty or not. And thereafter, there is an opportunity for mitigation and for aggravating of sentence. So there also, the court will go into detail. If it's not within a plea and sentence agreement regime, the court will go into detail and both parties will give their input into what the actual sentence must be and motivate for that. So the facts of the case will always, indicate what the sentence should be. And also within an administrative enforcement process, which is our compliance notices, for example, that usually is done also in conjunction or in parallel to the criminal convictions. Or sometimes it's done before the criminal conviction. So in that process also, there's an opportunity for them. We issue firstly a notice of intention, then they can submit representations on the instructions that we intend to give them in terms of what they should do. So in terms of that process, they also always have an opportunity to provide their side. I hope I've answered the first part, your first question. I think, Liesl, if you can deal with the second one, I think that falls more within your ambit, the second question from Mishka.
Using other mechanisms and not being water intensive. That was the second part of your question, if I'm correct, Mishka. Okay, before I get to the second part, can I just add on something to what Lize said? I think what Mishka described is the IGR processes, which aren't actually in place at the moment. If you read the Act, there are certain committees and forums and things that need to be in place so that there's better interdepartmental intergovernmental cooperation between these departments and levels of government. And that's what's missing. It's an important step. It's something that we don't like doing because we actually just want to go to court and fight with people because you're at the process where sewage is a crisis. But a lot can be resolved if only local government spoke properly with all the structures that should be in place. And we've been sent back to all of these forums that are actually non-existent, but it's a defense that's raised by the municipality the whole time. In terms of your second, there are many technologies. We are moving away from water-intensive systems. Our chief director was supposed to be here today, but she's away. And she's actually away inspecting one of these, and sanitation is not my area, but it's a no flush technology that doesn't use water. I think there's a Danish system that we're looking at, and as part of the norms and standards, we're going to be forcing municipalities to, as part of their scorecard, using a percentage of these technologies and setting baseline limits for them to be moving away from water-intensive driven systems, because water conservation and water demand management has been uplifted in the amendments to the norms and standards. Thanks.
Okay, thank you for that. I'm glad to hear that we are slowly moving to less water-intensive sanitation systems. You still have to respond to Ms. Melissa Stradom's or Dr. Stradom's question.
Yes.
Sorry.
Yes.
Do you guys need a quick
case law.
reminder? Yes.
No,
And
I've written it down. Yes, sorry.
Access to information, sorry.
Yes. No, everything she said was true. Even I myself struggle. It's like you need an environmental database of all of these cases. Lize, them at DFFE get it because I think they signed up for Tutorstat and all of those fancy systems. We don't always have those systems, but what I can do is, because as the question was being raised, I don't know if you're aware of our IRIS system. It has a public-facing part to it. That's where all the municipal information is stored and where they upload in terms of the green drop, no drop systems that the department does. we have sent through plea and sentence agreements. I will just double check if it is actually on that front-facing portal. And I will recommend that we start uploading there if it isn't. So whatever we have access to at DWS, we can then put there as a portal and a link for you to then get access to these plea and sentence agreements.
Okay.
Thanks, yeah, Mishka. If I can also add, Dr. Strydom, thank you for your question. I agree with you. I think this is a valuable thing if we can have the convictions somewhere publicly accessible. As you said, it definitely serves as a deterrent. And unfortunately, us as DFFE, we also only have access to reportable cases on our online systems. And then also here and there where we, where we get notice of it from another institution. So definitely it can assist. It can assist us. It can assist the public at large, and it will definitely also assist in deterring future contraventions. So what I will do is I will take the suggestion back to our sector enforcement unit and see whether it is something that they can investigate, perhaps.
Okay, thank you so much. That was a very comprehensive answer. I'm sure everyone will appreciate that. We have a hand from Prof. Flo, which Prof. Flo can now ask his question. If there are any other burning questions, you can ask them now as well. I see there are some questions in the chat that have also been answered by Ms. Liesl. Thank you so much for that. And yeah.
Yes, Mishka, thanks
Prof.
for the
the floor
opportunity.
is yours.
Can you hear me?
Yes, we can hear
Yeah,
you.
thanks very much for the opportunity, and thanks Lize and Liesl for a very informative presentation. We certainly learned a lot from your presentation, and I agree with Melissa that you should try and publish a paper from your presentation, or if you don't intend doing that, if you want to wrap it up into a dissertation or even a thesis, I think that is something which you can look into, or you can share the slides with us and we'll be able to pick some ideas from there. So I'm going to make a few comments very briefly and then give the opportunity for others to be able to also put forward their comments and questions. The first one which I want to put forward is that the requirement by the department that municipalities or water services providers should have licenses for them to be able to do the work which is required to them in terms of the constitution is clearly unconstitutional. That will not meet the constitutional requirements in relation to the autonomy of municipalities. One will argue that that requirement goes beyond regulation, and that it is intrusive to the extent that it usurps a function which is given to municipalities directly in terms of the constitution. So constitutionally, it's not permissible, it won't work. And then the second comment which I have is in relation to the suggestion that we should professionalize waste treatment at the local government level. I think it is something which is very fashionable, and people talk about it a lot, especially in the context of procurement. But I've come to learn through my reading in that area that we don't always need that for things to be able to work. The example which I came across is that of Netherlands, where supply chain management has not been professionalized at the local government level, and things are working very well there. And I argue that if we take students, young students or young people that have studied things like microbiology and engineering and keep them in waste water treatment plants for a period of about 2 years for them to be able to learn practically what happens, I think they can be able to do that work without necessarily having to go through the route of professionalization, because that entails that you develop a specific program for that purpose. And probably you have a number of universities that run such a program. And then I also think that your argument in relation to the duties of municipalities could be strengthened in relation to certain constitutional provisions. For instance, Section 237 of the Constitution, which obliges all organs of state to be able to execute or to perform their functions or to perform constitutional obligations diligently and without delay. That also applies in the context of waste management or wastewater treatment. And an argument can be made to the effect that that is a basic socioeconomic rights duty or a basic environmental duty, which should not be subject to availability of resources and all the other arguments which municipalities raise when you try to prosecute them. So they are really supposed to prioritize that and give attention to that. And your argument to the effect that we should lift the corporate veil, I think it is a good one, and it can also be reinforced with reference to accountability theories generally. And that is because, as you indicated, there's a lot of emphasis in our Constitution in relation to the principle or value of accountability, the need for organs of state to be accountable. And for us to be able to assess whether this is possible in any legal regime of accountability, there are certain core questions which need to be answered, and that ties in very nicely with the presentation which you've delivered. Questions such as who is liable or accountable to whom, what they are liable to be called to account for, by what standards are their actions to be judged, and what are the effects of finding them to be in violation of the standards that are applicable. Those are important questions. I think I omitted the who question. Who is liable for what? Or who is to account for what? I think those questions, when you put them together, it gives you a better idea of how we should be able to assess whether municipalities are accountable in relation to their wastewater treatment functions in terms of the Constitution and legislation. I think I'll leave it at that for now, and I can revert with more questions and comments later. Thank you.
Okay, thank you, Prof. Full. I saw one more hand from DK, but he's since lowered it. Would you still like to pose your question? Yes, you can pose your question. You are still muted. DK, you can pose your question after you've unmuted it. Okay, I'm not sure if there's anything wrong on your side, but if you still have a burning question, you're welcome to pose it in the chat and our presenters can respond to it. Yes, Lawrence.
Then I also forgot to unmute myself. Thank you, Mishka. I just wanted to say to the presenters, thank you very much. I found your presentation fascinating and very thorough. I had many questions along the way, but as the presentation went on, you answered most of them. My question basically is just that, Liesl, you mentioned that structural fundamental reform will be required to solve this looming crisis at the local government or municipal level for that matter. I'm just curious what you mean by that and what you anticipate, what kind of reforms would be required, if you can just specify in that regard, please. Thank you very much.
Lisa, you are welcome to answer the question.
Thanks. Can I start with the second question? It's newest in my mind. I think one of the main structural reforms that we've recommended is actually to Treasury in terms of budget allocations and the ring fencing of finance, because if your revenue and your budgets are not being used for O&M of a plant, we can take 20,000 people to court and do all sorts of things with interdicts. The plant is still not being upgraded and the proper expertise is not being put in place at the plant and money is being diverted. So that's one of the main aspects that we've recommended. And for Treasury to have understood exactly what the problem is, because, you know, ring fencing in of itself is an issue that Treasury has. that's one of the other structural reforms in terms of the mechanisms that you use at local government level in terms of having an honest conversation with themselves. There are structures, there are processes, there are procedures, there are line functions, all in place. But local government, and generally speaking, is not participating and not participating honestly. So how do you raise a defense to everything that's being stated to them, but they aren't coming in and having an honest conversation? When we call sector leaders, when we call municipalities, as what the minister did at the start of last year, certain mayors don't come. Certain mayors don't appear, municipalities don't come and hand in their corrective action plans. So those are the type of structural changes and problems that we've raised with Treasury. It is a massive task, but those are some of the things that we've highlighted with Treasury. The other question, sorry, Prof raised, there was an issue, it slipped my mind now. He raised the issue of us usurping their function, which is the way you've stated it, Prof. It is correct. It's a drafting issue related to the license. Licensing of a WSP function is quite standard. If you look at other countries on the continent, they are doing it and they've been doing it for years. I think it just came down to wording within the amendment, which has now been clarified with the Justice Department. So we aren't trying to usurp the function of the WSA or to step on their toes. But I think we've gone over that hurdle. But the license regime in of itself will be implemented for the WSP.
Okay.
If you can refresh my memory if I've left any other unanswered question.
No, that's fine. You did well. I think we have a lot of questions and comments. I think we have time we're technically over time. Lawrence, could you tell me, should we proceed with 2 more questions and then start wrapping up?
Yeah, I think let's take the questions. This is very interesting, so I'd rather we carry on. Thank you.
Okay. I don't know if you can hear me, DK, but we can't hear you on this side, and I propose that you should unmute and pose your question, or either pose it in the chat so that one of the presenters can respond. So you're welcome to open your mic and pose the question. Yes. Okay, so I'm not hearing anything yet. Dr. Stradom, you can go ahead and pose your questions or comments to the presenters.
Thanks, Mishka. My mind has been blown. I have a gazillion questions, but I'm sticking to the ones that I think are most pressing and things that I've been wondering about and thinking about for a very long time. Lize, you obviously spoke about the Mzinduzi case, the Rand West case, the Governor Mbeki case, and there we have nice 105A agree, or relatively nice, despite the fact that some of them refer to outdated laws. But I blame the defense attorneys for that, but be that as it may, or draft laws. But you've referred to those 3 cases where we have 105As. My question is around, so in your presentations, you mentioned that you were being creative in setting up structured fines with obligations. So basically, in this sentence agreement or in the sentencing, these fines are then ring-fenced for the job to be done, for the wastewater treatment to be fixed, and some funds earmarked for EMIs. But so in considering a lot of the prosecutions over the years, and especially where suspended sentences have been imposed or where there has been structured fines, the issue has also come up with follow-through and putting suspended sentences into operation. So I know these cases are very recent, but again, it's very difficult because this information isn't necessarily in the public domain. The follow-up on has the municipality now implemented these structured fines, is something that I'm very interested, because it's all well and good. You have a fine or a conviction with a court order that says, 150 million is earmarked for doing this. But the question is it being done? And, how do we track, and where's this information about the follow through, and is it being done? Because I know with some of the older cases, some academics have looked into it, have interviewed people, and it's then just like the information is there isn't really follow through. And I know, like for the NPA to put suspended sentences into operation, it's on old prosecutions. It's not always something you can convince them to do. I hope that made sense. Sorry, that was a lot of words. But the crux is just, post the structured fine or suspended sentences, how do we ensure follow through?
Okay, thank you, Dr. Strydom, for that question. I see another hand from Rafuo. I just want to, last chance, DK, do you want to pose your question? Okay, Rafuo, you can open your mic and pose your question or comment.
Thanks, Mishka. Liesl and Liz, don't you think that if we were to amend the Water Services Act and the National Environmental Waste Management Act to maybe give the Department of Water Affairs the type of broad remedial powers that the Office of the Auditor General has in terms of Section 5 of the Public Audit Act, that may help you a bit more to be able to address some of the challenges that you've identified, because in terms of the Public Audit Act, for instance, where the Auditor General picks up irregularities, they can approach an entity which is audited, like a municipality, and tell them this is the problem we've picked up. You should put together a remedial plan and tell us how you are going to implement it, and report to us how you are implementing it in order to be able to address the problem that we've identified. Don't you think that type of approach can help?
Okay, thank you, Prof. Well, Lisa and Liesl, you can respond.
Thank you, Mishka. I'll go first on Dr. Strydom's question. 100%. I agree with you. I think I did mention in my presentation that, convictions and sentences are beautiful, but if it's not enforced and compliance therewith monitored, it's just beautiful paper exercises. So I agree with you 100%. We, I don't want to sound like a typical government official now, but our lack of capacity is a real challenge that we are facing. Posts are being frozen due to non-funding and so forth. So not that it is an excuse, and not that we should hide behind that at all, because I think the time has come to prioritize these type of cases, and to also ensure that we get compliance with this, to ensure that we actually get the value of all the work done during the prosecution. So I know that in the past, the EMIs, that is our environmental management inspectors, they have, where there's a high profile case, they have followed through and they do regular checkups. They check. I think remember with these sentences that we got, there's regular reporting requirements. So that's actually an easy way for us as the enforcement authority to get information and just check every month. Is the information submitted or not? What is in the information? What progress is being made? And if there's any red flags, if we don't get sufficient reporting, if the progress is not sufficient, then it's easy for us to prioritize a specific case and go out on site, or apply to court for contempt of court order, or to get that suspended sentences into operation. So yes, that is the duty of the EMIs. Like I say, capacity is a challenge, but I think the way that these sentences are now being crafted, including reporting requirements, that's a way that we are trying to be clever and work around the capacity constraints that we might face, that would not allow us to go out on site and do routine inspections, but rather get a system where reporting is required and then red flags are being raised as and when that is not being adhered to. But now I agree with you. It is essential that that is being done, the follow through. I think Liesl, Dr. Fo's, of Prof. Fo's question on the amendment in terms of the Auditor General powers, the inclusion thereof, I think you are better placed to answer that.
Don't know why Liza would think that. Okay, let me take a crack at it. I think the Prof is correct. What we've actually been doing, because we've entered into agreements with the Auditor General, they are raising material irregularity queries with each of the responsible authorities where the environment is at risk. So they send us these referrals of the municipalities and we investigate them, and we've signed an SLA, an MOU with the AG. And what we've done now is we've just sent through a report to the AG, and they have agreed, because they also raise financial irregularities at the municipalities, and they're going on affidavit to assist us with many of our cases. So they will come and testify as to the financial misconduct or mismanagement that has happened at the municipality, either knowingly or unknowingly, for the MM, and we are going to be using them in our criminal actions going forward. So we are quite excited to see what happens in that space and how this would actually affect holding a municipal manager personally liable.
Okay, thank you for that, Lisa and Liesl. I think you've answered all of the questions. Before I hand over to Dr. Erasmus and Ms. Nesia Malungi, I'd like to ask if you have any final comments or inputs that you would like to share with the audience, things to remember going forward when we see issues of sewage and water in the news and things like that. You would be welcome to pose them now.
Okay, I'll go first. From DWS's side and from my personal point of view, we truly do. It may not always seem that way, as Lisa said earlier, don't we sound like a government official now, but we truly do welcome any sort of information report. Hey, have you considered this? Any type of information that could assist us with our processes. And I'll give you an example of something, because I'm in capacity development. And I'm not referring to the environmental profile at a university now, but specific to the water sector. We found that there isn't a pathway for if people want to work in the water sector, in inverted commas, other than as water quality. If you just Google and see what is out there, water quality comes up the whole time. But there's been an interesting report released by the Water Research Commission. We're wanting to come out with a pathway that people can work within the water sector and come up with divergent routes for people to then enter into, because we need graduates to come into the sector. It's the level of experience and capacity that we need is very constrained and not only limited to engineers, but we need environmental lawyers, we need water quality specialists, etc., etc., etc. But there doesn't seem to be an actual pathway. So any suggestions, not only on laws and amendments and things that need to be done, but particularly within building capacity within the water sector. Thank you.
Thank you for that, Ms. Liesl. Lisa, do you want to go?
Liesl actually covered me, so I have nothing to add on that. Thank you.
Okay. Okay, thank you for that. As Ms. Liesl said, reports are welcomed on how they can improve and how capacity can be improved in this sector. I'm now going to hand over to Dr. Lawrence Erasmus. Will then wrap up and tell us more.
Thank you, Mishka. Yes, I would like to wrap up, but it's not my role today. I'll hand over to Nessia to wrap up for us and to do the thank yous for the presenters. Thank you very much.
Thank you, Dr. Erasmus. Thank you, Lisa and Liesl, for delivering such an insightful presentation. Your thorough exploration of these critical issues on the urgent need. Sorry, can I take that again? Your thorough exploration of these critical issues, they did shed a lot of light on the urgent need for action. The clarity in which you conveyed the complexities of South Africa's water and sewage challenges were both eye-opening and thought-provoking. Your work is invaluable in raising awareness and inspiring solutions. Thank you again for sharing your expertise with us. But before we wrap up, I would like to kindly ask everyone to just switch on their cameras briefly so that we can capture this for our newsletter.
Yes, we're just going to take a screenshot of everyone's faces. So we'll showcase you on YouTube later. Okay, thank you. I think we're done. Thank you, Nessia.
Okay, we have come to the end of our program. I would like to thank you all for joining us. Thank you for your participation and enriching the conversation. Please remember to like, follow, and subscribe to all our social media platforms to stay up to date with all our CLES activities. And we'll also upload today's conversation on our YouTube channel if anyone wants to rewatch the sessions or share with their friends and colleagues. If there isn't anything else, I think that's goodbye for now.
All right. Thank you, everyone. Hope you have a good
Thank you so
afternoon.
much.
Thank you. Have a
Thank
good
you.
day.
Bye.
Bye. Bye.